Are you enjoying this podcast? Well, you have KUOW members to thank for that. KUOW members make the trusted local journalism and storytelling you hear on this show possible. Become a member today and help support the production of this podcast. It only takes a minute. Make a donation at KUOW.org or follow the link in the show notes. And thanks.
Welcome back to Soundside. I'm Libby Denkman. Washington voters this year are contemplating a wide-open race to replace the state's attorney general. The attorney general manages the state's largest public law firm, overseeing a staff of attorneys charged with representing public agencies and defending the rights of Washington residents, covering issues including consumer protection, civil rights, environmental regulations, and antitrust issues. And this year's race is especially interesting. The current Attorney General, Bob Ferguson, is running for governor. And that means without an incumbent, the office will see its first new AG in 12 years. This week, I'm interviewing the three candidates of the race, all who want to be the state's next top lawyer. And our final candidate to round out the three is Nick Brown. Brown has been general counsel to Governor Jay Inslee. He was the U.S. Attorney for Western Washington, and he has endorsements from Governor Inslee, Tacoma Mayor Victoria Woodards, Seattle Mayor Bruce Harrell, and more. And he is also an Army veteran, a former JAG officer in the Army. Nick, thank you so much for being here. I really appreciate it.
Thank you for having me. It's great to be here.
So to start out, why do you think you'd be the best candidate to be our state's top lawyer? And we are under a limited time frame here, so I'm asking for the elevator pitch.
Sure. Well, I think when we're electing an attorney general, we're electing both a lawyer and a leader and someone that has the values that reflect Washington state. And I think that my background makes me uniquely qualified to be the next attorney general. I have a very broad legal experience on both sides of the aisle. As a criminal lawyer, I've done complex civil litigation and private practice representing government entities and nonprofits. And I've worked on law and policy issues as general counsel to Governor Inslee and having served as a special assistant attorney general in numerous cases. I know that office incredibly well, and I think I can hit the ground running in understanding the very complex legal issues that that office deals with. Maybe more importantly, the office is a huge public agency, as you indicated. There are roughly 800 lawyers, 1,600 total employees, 13 offices across the state. It's a huge management responsibility. And I think that my background, having been most recently the U.S. attorney, but really throughout my career having an extensive career of leadership opportunities and responsibilities, know how to lead people, know how to set a vision and execute on that. And that's going to be really important from day one of taking over this office because there are really big, important challenges. And I think all of that makes me uniquely qualified to be the next attorney general.
I want to get to the knock that I've heard on your candidacy, and it is even from some people who are supporting you, and that's experience. You were the U.S. attorney for almost 2 years. You've been general counsel to Governor Inslee. Like we mentioned, there's many things to recommend you in your bio, but you haven't had elected experience, which is unusual for somebody running for a statewide office. Prior attorneys general over the last 50 years have generally served either in the legislature or the King County Council before asking voters to give them this job. The other candidates in the race do currently hold an elected office of some kind. How do you respond to the doubts that have been raised in some corners about the readiness that you have for this job?
Well, I'll be honest, that's actually the first time I've heard that particular knock. And I think people are forgetting about one of our most recent and I think most successful attorney generals, Governor Gregoire, former Attorney General Gregoire.
She is the exception.
She is the exception and showed how powerful and important that role was and the work that she could do leading the tobacco litigation, being a very successful Attorney General and defending some really important healthcare issues, Obamacare, all these things that she was involved in. So there's a good track record here. And, you know, if people want a seasoned politician, I'm not the candidate. But I think, as I indicated, my background as a lawyer is exceptionally more broad and has depth compared to the other two candidates who are good candidates. And, you know, there's good things to say, I think, about both of them. If you compare my legal experience, I'm the only one who's done complex criminal cases as a defense lawyer and as a prosecutor. No one else has done that. I'm the only one that has done complex civil litigation. I've argued multiple cases in the Ninth Circuit Court of Appeals. I've appeared in our state Supreme Court. These are all things that my opponents have not done. And I know what it's like to lead a large public law firm because I've done it. And that, I think, is the most important qualification. If someone wants a typical politician, they should vote for one of the other two people running. But that's not me. And I don't think that's what voters are looking for in this election either.
What about working with the legislature? That's something that Manka Dhingra had brought up about her experience in the legislature helps her know how, as Attorney General, she would interface with the House and Senate there. How would you work with the legislature, and can you hit the ground running when it comes to that?
Oh, absolutely. I mean, when I was general counsel to Governor Inslee, I interfaced with the legislature on a ton of different legal and policy issues. I was the chief of liaison to the AG's office as well and know what it's like to work directly with them, but had a lot of experience working directly with the legislature. And this is not a legislative job. If someone wants to elect the next legislator, then they should choose Senator Dhingra, because this is different. This is the chief executive for the legal department of the state of Washington. And so having that breadth of legal experience and executive experience, I think, is what drives voters in making their decision. If they want someone who's a seasoned legislator, that's somebody else. But that's not what this job is. And we shouldn't think about it like that either.
Consumer protection cases are a big part of the job of Attorney General. Prior AGs have won big settlements with tobacco companies, mortgage lenders. Bob Ferguson has logged some victories involving opioid makers, the poultry fixing case. These add up to hundreds of millions of dollars in settlement money for the state of Washington. Ferguson's office also had some losses. The judge in the Value Village lawsuit, for example, called the case burdensome and costly, and the state did have to pay several million for the company's legal fees. Is there a way that you would approach consumer cases differently than the current attorney general? How would you walk the line in what kinds of cases you would pursue as AG?
Well, it's important to note from the beginning that not every state has a separately elected attorney general to represent the people. In some states, you're appointed by the governor or you come into office in different ways. I think that the reason that we have a separately elected constitutional officer is to be that advocate for the people. And the way that interfaces with most of the general public is through the Consumer Protection Act and bringing cases on behalf of Washingtonians who are being subject to misleading business practices or abuse or all sorts of things where your rights as a consumer, as a resident, as a voter are being impacted by big actors. And that's where the value is most directly held and felt, I think, by Washingtonians. And I think Bob and his team deserve a lot of credit for being super aggressive and taking on some of these cases. The fact that you lose some from time to time means that you're doing the right thing. If you want to be safe and only take their easiest cases or cases where there's a real long record of precedents to base your case on, then you can play it safe and get much less impactful results. So I'm not troubled by the fact that every now and then you lose a case. That's what being a practicing lawyer, an experienced lawyer, that comes with it. Not everyone wins every one of their cases. And those that do are the ones that are being very, very careful and not, I think, best advocating for their client. So we need to continue to be aggressive in this space because I think all across this state, in both big ways and small ways, there are people who are being taken advantage of, particularly vulnerable populations, seniors, veterans, marginalized communities, immigrant communities that may not be as familiar with some of our systems or practices. And we see those cases arising all the time. I'm really focused what we can do to use the Consumer Protection Act and the AG's office as a whole to address some of the housing issues that we have, to make sure that people are buying or renting housing free from discrimination or free from misleading practices. And so we need to be aggressive. We have big problems, and the Consumer Protection Act is the most frequently used and powerful tool that the AG office has.
As Attorney General, Bob Ferguson helped push for changes in state law related to police use of force. His office also charged 3 Tacoma police officers in the death of Manny Ellis. That was the first time the state attorney general had ever criminally charged police officers in the use of deadly force. All 3 officers were cleared by a jury last year. One, Timothy Rankin, has filed a multi-million-dollar defamation claim against Ferguson's office and local officials, saying that his prosecution was politically motivated. Would you have charged the officers in the Manny Ellis case?
Well, I think it's important to step back first because public safety is a hugely important issue in Washington state. It is something that I hear no matter where I go, big cities, small cities, Eastern Washington, Western Washington, public safety, criminal justice are usually one of the top 2 or 3 issues that I'm getting. And part of criminal justice is law enforcement and law enforcement accountability. And we need to be doing everything that we can to make sure that our law enforcement agencies are well supported and doing their jobs well. And when they don't, that they're held accountable for that. That is the way that you build greater trust in the community. With greater trust, you have greater safety, I think, in my experience. I've been a lawyer for 21 years. The vast majority of that time is around criminal justice issues, the criminal legal system. So I think I bring a lot of experience to that. In that particular case, I haven't seen all the facts and evidence. I didn't review the case file, and I don't think anyone should say I would have done something if they hadn't actually looked at the evidence. Based on what I saw publicly available, absolutely I would have brought that case. I think that there was really troubling behavior in that case that certainly looked to me to violate Washington state law. And based on that and what was publicly available, I think that was the right decision. Again, looking at the case file, talking to the witnesses, evaluating that with a team is what you need to do before you make that ultimate charging decision. As the United States Attorney for Western Washington and have previously been a prosecutor in different contexts, I know how important and impactful it is when you sign your name to an indictment. Every indictment in the Western District had my name on it. It was a responsibility that I took very seriously. And certainly when you're charging law enforcement officers, I think you would feel that weight more significantly. But based on what I've seen, yes. And the fact that you lose or win a case, that shows how our system is supposed to work. Those gentlemen had their time in court. The jury got to evaluate all the evidence, and they were acquitted. That seems like a justice system working properly. And I'm not dissuaded by the fact that you're going to lose a case from time to time. You know, I've seen the subsequent litigation and the civil cases and the defamation case. I don't want to comment on that, but based on what I know, I think that was the right decision.
The Manny Ellis case led to a bill that went before the legislature earlier this year, HB 1579. That bill would have created a unit within the Attorney General's office to pursue charges against police for deadly use of force. The bill failed to get out of committee last session, but it could be renewed in the future, revived. Republicans had pushed back on this idea of creating a unit like that in the AG's office. They said it was an improper expansion of power. They argued that local prosecutors can already bring those cases if needed. If elected, would you support creating a unit in the Attorney General's office for prosecuting police? And what is your response to questions that Republicans had raised of overreach?
Well, to get to the bottom line, yes, I think an Office of Independent Prosecution is the right direction for the state of Washington. Following on some of the things that I mentioned earlier, I think the way that you continue to build trust in the community is to have an independent voice looking at some of these most difficult and complex cases. And they really are. And no one should talk loosely about the fact that we're charging law enforcement officers who we entrust with a great deal of power and responsibility with crimes when they abuse their responsibility and violate the law. But I do think one of the ways that we can continue to do that is to have an independent office. I know over the last couple of years, there's been a lot of debate about where that office should live, whether it should be in the governor's office or the attorney general's office or somewhere else. From the outside perspective, it certainly seemed like no one wanted to touch it, frankly, and because it's hard and messy and politically fraught. But I know what it's like to make those tough decisions. From my perspective, it doesn't make sense for it to live anywhere else but the attorney general's office. I think some of the concerns, critiques, complaints that I've heard from Republicans or others are not completely invalid. I understand that when we're talking about such a weighty decision that people want to make sure is not politically biased or motivated or anything like that. But we need to make sure that we continue to do everything we can to make this a system that people can believe in. And I have a lot of experience in making these tough decisions. And I think it is something that should the legislature enact such a bill, that is a responsibility that I would take very seriously, and they make sure that we have the right team in place to bring those cases when they happen. They do happen. They're not super frequent, but we need to have experienced prosecutors, investigators to do that work and to do it well. And I like the idea of that living within the Attorney General's office.
Let's talk about the opioid crisis and the role of the criminal justice system in addressing it. As U.S. Attorney, you oversaw federal prosecutions for a lot of drug cases, including busting traffickers and interstate issues. Last year, you told my colleague Scott Greenstone in an interview that you favor focus on treatment and things like housing and other programs to help address the opioid crisis rather than just the punitive approach. But I do want to clarify something. On sentencing, you told Scott Greenstone that you instructed your attorneys whom you supervised to, quote, go into court and advocate for the least amount that is necessary. Am I correct in interpreting that to say that you were advocating for lighter sentencing for drug dealers?
I think every prosecutor should ask for what is necessary, but should not ask for more than is necessary. I don't view that as particularly radical or crazy thing to say. If we have prosecutors that are using their immense power, and I've been a prosecutor for most of my career, if they are using that power to ask for more than they think is necessary simply because they can, they are not doing justice. And we have seen the detrimental effects of over-incarceration, particularly on communities of color and poor communities. When I was a prosecutor, when I was the U.S. attorney, there's always a range that you can ask for under the sentencing guidelines in the federal system. And oftentimes my team could walk in and ask for decades in prison. But no one on my team should ask for that if they didn't think it was necessary, whether that's a drug crime or a financial crime or any other sort of crime. And so my guidance to them is just determine what you think is necessary and do not advocate for more. I think that makes a lot of sense. And I also think that we have to recognize that about 97% thereabout of the people in our state custody, they're going to get out one day. And we need to be thinking about what is going to happen when they get out. And are we setting them up for the opportunity to enter their community and succeed? And there's plenty of data and studies to show that, in fact, excessive sentences can have decreasingly effective results. And so my team understood you ask for what you think is necessary to do justice, to address the concerns of victims, to help rehabilitate that offender. But if you think more is not necessary, you shouldn't ask for it. That's not your job.
I think a lot of people hear that and they say, I agree for somebody who is, doing simple possession or using it themselves. But then there's maybe a pause and a difficulty to make that leap for somebody who is distributing.
Sure.
So, what's your response if somebody feels like Nick Brown, he's soft on crime?
Well, look, I'm not going to convince everyone that my approach is the right approach. I would say that I have decades of experience in doing this work and both representing people and representing my country and government. I think that that's a right philosophy to have. If you look at my record, I've certainly advocated personally and as U.S. attorney from some very serious sentences. But again, we have to use government power very carefully. And if anyone thinks, in fact, no, you should ask for more than is necessary to do justice, then I just disagree with that philosophy.
Let's move to the subject of transparency. This has come up, especially in media circles. So yes, maybe this is a little self-serving for us, but I think it's also in the public interest that public agencies be transparent and responsive to public information requests. Attorney General Ferguson has been dinged by a judge back in 2016 for deleting emails relating to the Oso landslide. His office also admitted to withholding 100,000 records in a lawsuit against the Department of Social and Health Services. Those are cases where documents, have the engine of the court behind them to access them. But a reporter, an average person, when they request a record from the AG, we still have to physically mail checks. There is a really burdensome process. The time to actually get any access, if you get it at all, is very long. I understand that there's also a pushback from agencies who feel like they get an enormous number of requests, and those can bog down and cost resources. How would you approach transparency as the Attorney General?
Yeah, and I think there are two separate issues that are related here, but that are raised by your question. One are the types of transparency issues that might come up in a case. So discovery practices, when the other party is entitled or asks for certain records to help prove their case or disprove your case, that is a normal give and flow of discovery. And every agency should be doing their best to be fully transparent, to provide all the records that they're obligated to provide, to make sure that litigation is done in the most professional way, consistent with our rules of professional conduct, and serves the end of justice. And so, as you mentioned, there were a couple cases that were highly public where the AG's office had run afoul with some of those obligations and were penalized by the court. My understanding is that they have created a new unit to help address some of their discovery practices. My hope and my commitment would be to continue to bring best practices to the AG's office to ensure that we don't make those same types of mistakes. I haven't seen anything that indicates to me that that's a systemic problem, but there were a couple big cases where they were penalized, and that's what happens as when you're a practicing lawyer. The separate but related issue is about public records. And I think you highlighted that for a very long time, the AG's office was using what feels like very antiquated process to provide records. I think that's actually changing this year. I don't want to say that definitively, but my understanding is they're moving to more of a digital or cloud-based system.
I don't have stamps. I don't
yeah, I know, or CDs
stamps.
Or thumb drives anymore,
yeah, exactly,
right?
Yeah.
But I think my understanding from talking to folks there is that they are moving to a different system that hopefully improve that practice. Not surprisingly, government entities and agencies are often woefully behind private sector or other companies about how we do data storage and all those things. So the state as a whole, the AG's office included, needs to continue to invest and spend money and improve their practices. So hopefully you won't have to send in, $2 in a stamp or get a CD or a thumb drive back. But we need to continue to improve that. And also the AG has an obligation as part of our duties to provide public records guidance to other state agencies to make sure that they're using their best practices. And that's an area where the AG needs to continue to work collaboratively with with local jurisdictions across the state. When I was Governor Inslee's general counsel, I'm super proud that he stood by his promise to never invoke the executive privilege. As his general counsel, that was my obligation to make sure that he did. I sat on the Sunshine Committee, the Public Records Committee, that always advanced more transparency in government. Washington has a really robust transparency system, more robust than most states, and that's something that I think that makes our state strong and gets back to that foundational point that I was making earlier. This is how you build trust and credibility with the public, particularly now when there's a lot of distrust and a lot of questions about how government operates. The more that you show and the more you explain your decisions, the more trust that gets built, I think, in the community.
We just have time for one more question. And it's the same that I posed to your Democratic opponent, Manka Dhingra, when I interviewed her this week. It's a 3-person race, but 2 Democrats means that you're going after the same voters, at least in this primary, the same Democratic voters, maybe some of the same independents. A lot of your policy positions, because you're both Democrats, can feel similar to voters who are looking at this race for the first time, trying to understand, who to pick. How would you differentiate yourself? Why should Democratic voters say that you are the choice for this primary?
Well, I think your framing of the question is right, because there's one Republican. He seems fairly likely to get to the primary and to the general election. So for Democrats, the decision that we're going to make in just a few weeks is really important, because it'll decide who the Democrat is going to be moving on to the general election. As I said in the beginning of this, I think there are things that make me uniquely qualified as a lawyer and as a leader. And we're going to be hiring someone to lead the largest law firm in the state. And I think we should be trying to hire someone who has a really broad depth of experience as a lawyer and as a leader. And I think if voters, when they're sitting down and reading the voters' pamphlets or paying attention for the first time to this election, and they want to compare my experience with Senator Dhingra as a lawyer and a leader, I will take that debate anytime, because and I think she's been a really good state senator, and I don't have anything negative to say about her practice in Olympia. But as a lawyer, she's been a King County prosecutor, and that's about it. And my experience as a lawyer is much broader and much more complex work. And I think that is going to be something that voters should care about. And leading the people of that agency and to be able to hit the ground running. I know what it's like to set a strategic vision for the office, to execute on that vision, to work with stakeholders of all types, to move that agency forward. Because come January 2025, we're going to be facing some really important challenges. The prospect of a Trump administration defending abortion access, doing everything we can to implement strong environmental policy, keeping Washington safe. I think Washington voters want someone who's ready to hit the ground running and has the experience and depth of practice to do that on behalf of the people, and I think that's me.
Nick Brown is a former U.S. attorney for Western Washington, and he's running for Washington State's next Attorney General. Again, that primary is August 6th. Oh my gosh, it's coming up fast. It really is. Thank you so much.
Thank you very much. It's great to be here.